This is our second meetup group. My name is Dennis Mehta. We have a distinct pleasure of having a good friend of mine over here, and I'll talk about that in a minute. But first and foremost, I want to take an opportunity to say thank you. Not going to spend too much time talking about PGA or about each of us individually, but just enough to say, typically the summer months are the slowest months, and in some of the other groups that we belong to, Thai, Indian Diaspora, we have seen attendance go down substantially in some of the areas. Enough to say that whatever the number you have here, you multiply that by 3 or 2 or 3 at least, that will be your September, October, November target, Sunil. Okay, so Vijay has asked me to say a few things over here. So before I begin, I wanted to say Michael, who is a good friend of ours, a fellow Indian Israeli, as other than Israeli Indian, but he's a lawyer too. So I said, okay, the first time I met him, I said, okay, you're a lawyer. Well, that doesn't count much in my book. And he asked me why. And I said, there are 2 types of lawyers. The ones that are real brainy lawyers who do like all this super duper patent stuff and IP stuff. And then there are other guys who are rest of the lawyers, which are basically chasing ambulances. And he looked at me, he says, well, I belong to the first group. And I said, well, if that is so, then that's called a true lawyer. Michael Ben-Shimon has his own entity up here, and he's also associated with PGA. Very proud to have him as part of our group, simply because his practice consists of nothing but IP issues. So IT companies and also the other tech companies looking at the IP part of the business, that's the kind of a person you want on your side. One of the few things that I did ask him to, if it's okay to talk about it, but I will anyway. He's had his companies, or the companies in which he has actually helped be a client to, have had 4 exits. Shall I say them? One was to Microsoft, was at 500 plus million. Second was to Qualcomm. Third was to BlackBerry, and the fourth was?
Well, Cisco. I have a full
Cisco. Oh wow, he's got a full presentation. So, well, after I looked at that, I said, you know what? An attorney who can actually show his client exits of this type, that's the kind of an attorney you want to have in your side of the equation. There's a lot about patents. It's not just inventing something. It's a process patents, regular patents. And I'm sure Michael is going to get into it. So without too much ado, I just want to hand it to over to Michael.
Thank you very much.
So good evening, everybody. As Dennis mentioned, I'm an Israeli. I'm here in the United States 11 years. So forgive my Israeli accent. Today we're going to touch about intellectual property strategies and trends. And I'm not going to talk about legal issues. We're not going to analyze Supreme Court decisions or PTAB decisions. We're going to talk about the business aspect of intellectual property, specifically how you can leverage IP when selling your business or trying to raise investment from VCs or angel groups. We found it very unique tool to help startup companies to grow their business. We meet a lot of entrepreneurs who seems to overlook the benefits of IP. And here we're trying to educate you as founders, as investors, about the benefits of having strong IP in any company that you invest or company that you are part of. So I founded my company, M&B IP Analyst, 5 years ago. I was part of a law firm before that brought me from Israel. And the reason I quit decided to go on my own journey were for 2 reasons. One, I'm entrepreneur. I cannot work for someone else. Second, I felt that traditional law firms cannot cater to startups. I had to bill by the hours or by the minutes. If someone had called me after 5 minutes, I had to send a bill. And startups have limited resources. So I said, no, this business model cannot be sustained. So I came with a different model. I tried to help startups. Our tagline, and also the brand promise of MNBIP analysts is accelerating innovation, seed to exit. So we are with the company the minute there is the initial idea until the exit. And I can give you a number of examples follow about companies that we helped since we met first time on the coffee shop. We drew up napkins, the basic idea, and then they were sold for the big corporations for hundreds of millions of dollars. My background is, other than the patent law side, I did some science, graduated computer science, mathematics, and physics. I was able to complete that in 3 years, 3 majors. I served in the Israeli Air Force as an engineer. I helped develop radar systems. Then I served or worked for the Israeli aviation industry. So I bring also some experience as a software engineer. It helps me to talk with my clients about technology in the same language that they use. So as I said before, this is where I came from, Tel Aviv. And I mentioned that not just because I really miss this beautiful beach, and I've been there just 2 weeks ago and spent some time enjoying the view and the weather. But Israel became, in the last 10 years, a strong hub for startups. And I think the reason for that is that, A, there is great talent of technical people, engineers, scientists, graduates from the Technion, had some time serving at the Air Force intelligence units. B, there is an ecosystem built for startup companies. And unfortunately, I cannot find it in New Jersey. And I think PGA is one of the first accelerators trying to build an ecosystem like that. Ecosystem means that you have a group of entrepreneurs trying to build a business. You have investors willing to invest. And you have service providers like patent attorneys or corporate legal CPAs are willing to work for equity or defer payments until the startup is up and running. And I think over the years, Israel became today, well, I'll put it like that. If you compare Europe to Israel, you will find more companies from Israel traded in NASDAQ than companies from Europe. And I think the population of Israel is 8 million. The size of Israel, the land, is as the size of New Jersey. So if you're trying to compare, I think it's, to me, it's unbelievable. So we help startups at MNBIP, and that's my experience over 15 years. And we don't act like, okay, you have an idea, let's file it. We help them to build a real story behind their IP. And here are some examples of companies that we help seed to exit. Velocity, a friend of mine, Tal Tamir, we met at a coffee shop, we drew an idea. Then it was the first Y gig, 60 gigahertz band, or communicate wireless over this band. There is infinite bandwidth. You can stream 4K in minutes. You can use a docking system without any cables. He sold the company to Qualcomm for $400 million. Another recent acquisition happened actually 6 months ago. Celso acquired the Datorama for $800 million. First marketing analytics tool. Really, the first to come with the idea, okay, let's see what you spend on Facebook and Instagram really makes sense for an advertising agency. Another example happened last month. They just closed. Palo Alto acquired Twistlock, cybersecurity company, $400 million. And there are a few more. And we're proud of that because we feel part of the team. And I would not say that the IP was the only reason, the only reason they acquired the companies, but definitely it was a big decision maker for the company to making the acquisition. I can, I will not say specific names, but one of the name here, the IP helped them to win a bid war, and Amazon make a big payment just to get over this company because they had real patents that Amazon really liked.
So as part of that equity, just so that you guys understand, in the beginning, you worked with them with less capital, but more in equity side.
Yeah, we help them. So if they have no cash, we'll take some equity. If they want to defer payment, we'll defer payment. I made some nice exits as well. I was aligned with them, and that's definitely something I appreciate. Also, my wife. So let's talk about intellectual property. Any works that you create or invent is considered as intellectual property. And the IP rights are basically belong to the owner of the creation. So if you came up with a story and you publish that, that's your own IP, that's your own copyright. If you come with a brand name, it will go to the company, but if you have a patent, it will go to the inventor. If you're part of a company, you will have to assign your rights to the company because they pay for the IP. But think about that if any employee or any engineer that is part of a startup company, he is entitled to be named as the owner, or as the creator of the IP, but he needs to assign the rights to the company in order to so the company will enjoy the benefits of the intellectual property. So IP, basically, there are 4 categories. Patents, that gives the right to exclude other from using the invention. Typically, it's for 20 years, since the day of the filing. You can file patents basically on any technology advanced. It could be a formula for drugs, it could be a software, it could be a piece of circuitry, it could be plant, it could be a design. So, famous lawsuit would be I would say one of the lawsuits was a really legal battle between Apple and Samsung was around the design of the iPhone. And they won over a design patent. Trademark is to protect the brand. And it could be a tagline, a slogan, it could be a logo of the company, the name of the company. We trademark our logo and also the tagline, accelerating innovation, seed to exit. But Apple is another bigger example than my firm. So they have the iPhone, and a real story is that the iPhone was not belonged to Apple. It was a trademark that initially created a national semiconductor, and through many acquisitions ended up at Cisco. So Apple, when they launched iPhone, they had to go to Cisco, and they reached some cross-licensing deals to use the name because they didn't want to have a legal battle with Cisco. Apple, the first name, was also an issue of a trademark because, if you remember, it begins as Apple Computers. And Apple Records is a company in London that, I think they signed the Beatles. So they objected to that. So Apple said, we sell computers, we don't sell music. But when Steve Jobs came with the iTunes, wait a minute. Well, now he's selling music. So they went to court, and then they settled about the use of the name Apple. So it's really important to think about trademarks, to think about your names. And the advice I can give is, come with your unique name. It's always good. It will always save you some time in trying to get around what is already exists. Trademark is another way to protect your intellectual property. And that's something very vague. What is a trademark? So it's a secret. You're not allowed to tell anyone. However, if the secret is revealed through reverse engineering, that it's not a secret anymore. So basically you can lose all your rights on this piece of IP. A famous example for a trade secret is the sauce that is being used for Pizza Hut, or Coca-Cola have a trade secret on their formula they use. In technology, I highly recommend to carefully consider not to use trademarks, because if source code is easy to reverse engineer, semiconductor can be look at the layout and understand what's going on. Also in pharma, I think any compound can be understood by looking at under a microscope. So, it's a way to protect your IP, but has to be do in a very, very conservative way. Last category is copyright, and it's basically creation. Creation of, could be of music, writing, could be a poem, a story. Even a code can be copyrighted, but you copyright the actual use of the code, which means the way you write the source code or the code itself, that's copyrighted, not the actual operation of the code is copyrighted. So, as example, Aliv, we try to show you the differences. So, the label would be copyrighted. The trademark and the slogan it will be, the name of the company, the slogan, the logo is trademark. Patent would be on the design of the bottle and the drug formulation. So in the one product, you see how you can really encapsulate the three different forms or categories of intellectual property. So as I said before, other than the legal aspect, it's business tool. And that's the one thing I would like you to take from this presentation. Maybe some of you are inventors, some of you are investors, some of you CEOs of companies. Think how I can make money with IP. It's a business asset, it's a business tool to help you to grow the business. So it can bring with you, IP can brings value by attracting investors. Every time that I go and pitch by a company for investment, I ask about patents because that's what I know, and I want to see that they will have some exclusivity in the market. If there is, the CEO say, oh, I don't believe in patents, or we don't want to spend money on that, or I don't think that I have a patentable idea. So I said, why have to spend my money if you believe that what you're doing is not unique? So it's a way to interact, to really encourage investors to join the company. It helps you to control the market. So if you have a patent, you can stop others from using your invention for, say, up to 20 years. And sometimes even if you get a small advantage, that's huge. I think the prime example is Amazon. They had a patent on one click, talking about back in the 90s. And they were able to stop Barnes & Nobles for the high holiday season from using the similar product because they had a patent. Sales over this month were billions of dollars. So, one IP piece, they invested about $25K, generate them a value, over $1 billion in revenues.
Michael, can I ask you?
Yeah, sure.
So if I look at the patent, so are those filed at the country level? For example, a patent in the US, patent in India and elsewhere? Or is it like applicable, filed locally, but applicable globally? Can you just highlight a bit?
Yes, so patent is, it's give you protection in the country you're going to file in, okay? If you'd like to have international protection, you will have to file in each country. There are some regions, EPO, it's European Patent Office, will protect the entire European Union, so you can save some money there. There's something equivalent in Africa and in Australia. But I will touch it later. But when you China is a big market, and now I don't know. But if you would ask me 6 months ago, I said definitely file in China. The reason is many players are in China, and also the Chinese government incentivized local companies to have IP. In the last 5 years, China became #1 in international filings of IP. It's a big market. Now, there are second thoughts because of the trade war with the U.S. I think it will go over soon. But my recommendation to my clients is really consider China. There are two markets today, China and the U.S. Europe, it's okay, but where the business, especially in tech, software, hardware, is these two regions.
But if they reverse engineer almost every patent or every big invention, so does it make sense for you to take anything to China that has high IP content?
If I file in the US, I will file in China because you can enforce IP in China. The way to do it is to go with a local company. We had a case that my client partnered with Baidu, and Baidu acquired their portfolio and filed, and I think they had like a legal battle with Alibaba or another company in China. And the beauty of that back then, I don't know what the rules today, is that every patent they acquire from the U.S., from a U.S. company, they get back money from tax incentives from the Chinese government. So basically, it was a free purchase for assets, and that they use that to leverage on their competition. So all the discussion we have now is good examples why you need IPs. If you have no patents, then what you can do. I will touch the last bulletin, hedging against legal disputes. So, in startups, especially, you will not go after Amazon or Microsoft at the outset if they infringe on your patent. But likely, when these big corporations like to stop small companies that they see competitions, they will try to back them with their IP. So some of my clients will get letters from IBM, for example, will say, oh, we invite you to look at these patents. Maybe you want to buy them. If we ignore that, the second letter is, let's talk. Okay? If the startup has some patents, we can send a letter back. Okay, this is what we have. Maybe you want to take a look at our list. And that's, it creates like a balance between what a small company has against huge company. And usually, the way it's resolved typically is by cross-licensing. So, okay, we'll give you use on these patents, you give us use on your patents, and that's it. We had an example that such a legal dispute ended up in acquisition of the startup that we represented, because they say, okay, the value of the patents makes sense for us to buy the entire company. So, again, it's a tool, it's a business tool beyond, being legal way to encourage innovation. So revenue streams of IP, it's all ears, so it helps with sales and collateral. I will touch that. Some cases, companies want to grow and need a loan. They don't want to go to investors and dilute the company any further. So we'll go to some banks. Silicon Valley Bank is one that really helps startups in this area. Okay, what is the collateral that you have? I don't need your PC. I don't need your desks. Show me, real assets. So against the investment, against the loan, they will assign, or they put a lien on the IP of the company. So if the company does not have any IP, then, what you're going to put a lien on? People can leave anytime. Another way to generate revenue is standards. If you have some folks here that from telecom or telecommunications, so IEEE encourage some standards. So companies file patents, contribute to the standards, but in return take some royalties for companies that are using the standards. So that's a good way to generate revenue. So we're going to go over some strategies that we implement when we help our clients. One is to evaluate the core assets and decide what type of protection you need. So really, cash is a king in any startup. They always look for money. Okay, no matter what, they always look for another round and another one and another round, and they don't want to invest money on expensive IP stuff. Like they don't want to pay attorneys, they don't want to pay the USPTO. Or, if you go to China and file in India, that's expensive. So they say, okay, well, I don't need to invest that. But as I demonstrated before, it's really important. It's a key asset for the company. So I encourage all my clients and people that say, okay, even if you don't engage with us, look carefully at what are the core values or the core proposition of the company, and try to see how you can protect that. And it can be protected by filing copyrights, and it's $400, and you can go online and register that. Could be trademark, which is relatively cheap. You can publish a paper and stop others from using your invention by creating public disclosure. But it has to be a discussion in the company that's what we have, that's our value proposition, that's why we're going to pitch investors, and now how are we going to protect that? Because if there is no protection, if you don't take it in the back of the mind, then there will be a day that they say, oh, shit, I had to listen to, excuse my French, we should have took this advice. I will share with you two examples. A potential client and became a client, they called us, say, we have a problem. We were under due diligence. They were ready to put 10 million in the company, but then they found these two patents that your competitor started to assert against others. So what's going to stop him from using the patents against you? And they called me and said, nothing, because you have no really something to defend. Because, if you had filed for some patents, you can use that for the cross licensing techniques. Or if you were worried about their IP, maybe you can design around their IP and have your own patents. So that's one example. Another example of clients that were already ready. They have the product, they had some sales, and they try to get investment from a strategic partner. Strategic partner means companies from the industry that are going to do, for example, an OEM. And this strategic partner said, if you have no IP, there is no way we are going to invest, because for us it's too risky. We don't want that our competitor will sue us infringing their products through using your software. So again, it's very important that any startup will go over what they have and see how they can protect that. So I say it's expensive to do IP. Patents are the most expensive form of intellectual property. Looking at numbers, pharma, you'll look, patents in this field about 50K start to finish. Software, it's about 25K start to finish. That's East Coast price. If you go to the West Coast, you have to double that. Now, there are some cost-effective ways to file for patents. As a startup, I always look at the defensive. Look at the file patents that protect your core technology, that if someone will go after you, you can use that as a negotiation tool. File provisional application. Provisional is a cheaper way to use the USPTO system to protect your invention. There are some ways that the USPTO, the United States Trademark and Patent Office, helps inventors and helps small companies. It's called, they have a program that you can pay micro-entity fees, which is like 25% of the usual fee. You have programs that provide acceleration at no cost. Use that. The biggest question I always been asked is how many patents I have to file. And there is no really number. I met some CEOs say, I don't believe in patents. And I met CEOs that say, I want 50% of the round to invest in IP. Both approaches are wrong. It has to be tied to a real strategy to understand what's the value that the IP can bring you and what you want to protect. So when we try to analyze the portfolio and the number of patents in the portfolio, we look at the investment in the research and in development, R&D. We basically use a number that up to 5% for the 5 years investment in R&D should be allocated to IP. We also try to cover the core technology. So you cannot do it with one patent. Usually you need to define a portfolio. And we also look at your competition and see if there are patents that we can file to block them from penetrating our clients' market. One thing I can share with you is if you say, okay, let's file one patent, and that will solve our problem, then my advice to you would say, and that's not a legal advice, but a friendly advice, use the money and take it for vacation. The reason is, if you have one patent and someone wants to sue you, he can kill this patent through litigation easy. The cost today through IPR, it's a procedure with the USPTO, I would say 250 to $500,000. But if you have a portfolio of 10 patents or 20, 25, then it's, you have to $500,000 times 10, $500,000. So it's a big number. And for startup companies, usually they will write a check to acquire the company and not go to legal battle and pay attorneys. So thinking about IP, you need to think about developing a portfolio.
Can you please explain that? Let's say somebody has an idea for an app and he wants to file a patent for that. Now, how do you create a portfolio around it? I mean, why would you go about filing 5 patents about it? It's just an idea. I want to come up with an app, but I want to protect that idea. So, what would you do in such a case?
What we do is we don't look at the main idea. We look how we can extrapolate that to different markets, and we protect that. And then we analyze the technology. Okay, so if you use, for example, special algorithm to optimize the utilization of, CPU time, then we say, okay, let's work and find how we can protect that as well. We'll look at the design. If it's like a very nice user interface, let's see what are the features in this user interface that make this app very unique and very, magical to use. So we look around and we do what we call patent mining sessions. We brainstorm with the engineers to see what is under the hood, and not just, oh, this is the app, that's what the app does. That's the way we can find and extract more patent ideas than just, one idea.
Then that would mean that just for the idea, or just to protect that idea, you would end up spending much more than maybe the development cost.
So sometimes I would advise not to file that, because not everything can be protected, but not everything makes sense to spend money to protect. Okay, it's a case-by-case evaluation and decision. And you can, if a guy would come to me, oh, I have an idea, I have a new app, and I want to file one provision application just to show off to the investors. So come on, it's not going to work, because sophisticated investors will know that it's fake. Everyone can go to the USPTO and file a paper and say, this is my provisional.
So
Okay?
go back to the example of what the first slide or second slide he had up there. Half of those companies, you don't even know they existed before. Velocity, nobody knows who they are, right? And how big was the deal? 400, 500 million? So the size of the exit there justified having a ton load of patents as and variation of patent could mean things like, as against a simple idea, it could also be used on for Samsung this way, on an iPhone this way.
Yep.
I'm sure you know. He can sit and talk to you a lot more intelligently than I am doing, but my point is, by doing multiple patents, you protected true value in that,
Thank you.
You're welcome.
All said, all understood good, but at the end of the day, it costs dollars, right? I'm a startup. You just mentioned you have patents which goes in millions. I'm a startup. I don't have that kind of money. So how do you make
help me make a decision that, hey, I have a great idea, you should patent, but I don't have the money to put it. What do you do in that case? And I'm yet creating something which I have to lure investor to say, hey, come invest in me. I don't have the money to show up front to the patent office that, hey, here you go, file it.
So, what we do is, regardless to the discussion, but if you're a startup and you want to develop a product, and once you raise money, you need to protect the development. So that's the time you need to start to file patents. If you'd like to file beforehand, and before you pitch to investors, then there are low-cost filings like provisional application. Provisional application gives you 1 year to file non-provisional, a real patent application. Real provisional application is relatively, I would say, not cheap, but it's low cost relative to,
Yeah, can I make a comment?
Yes, sure.
I have been in the patent side for a long time. What he is asking for is, my suggestion would be file one patent, then as you grow, file more. So, it's not a either or decision, means you
Yeah,
can start
definitely.
with
We
one
built this
patent.
portfolio over years. But just to make sure that I'm clear here, it's not one patent for the entire time of the company. That will not survive. But over the years, you need to develop a portfolio. And what we do with our clients, we define a strategy, okay? So first stage, that's what you should do until you the A round. That's what you need to do in the B round. Okay, C round, you're looking for acquisition. These are the targets. Okay, if you're talking to Qualcomm, Qualcomm likes to see real patents. Boom, we go and extrapolate the number of filings. I'm not sharing any secrets here. You can go online and see how many applications filed by Velocity, for example. So their portfolio size at the acquisition was about 60 patents. Okay? It's a nice number for a startup company, and they were sold after 4 years since they started.
Well, every company who has a startup has to have an exit policy. Theirs was maybe 4 years. My question is, you talk about provisional, non-provisional, right? At the end of the day, as a IP legal consultant, you're going to help startups figuring out if there is a alternative patent already filed. So when you go and let's say I file a non-provisional because it's low in cost, I file a non-provisional. What is the probability that somebody else who has a similar idea can sue me and say that, hey, yours is a non-provisional, I'm filing something else and my idea goes just out right there, apart from whatever investment I've made.
So you're asking about the risk that you will be sued because you file a patent application?
Yeah.
Well, you can be sued for any reason, first. Second, if you have a patent application, so at least you have a tool to fight it back. Now, if you are consider about having your idea in public, then there are ways to unpublish patent applications, so no one knows that you have filed for patent application until it's granted. By the time it's granted, it's your patent, it's real asset that you can sue others with that. Okay?
That helps. Thank you.
One comment you made, that you can stop from being public.
Yeah, if you file in the USPTO, and that's only related to the USPTO, you can, once you file the patent application, you can request for non-publication, and they will not publish the application.
Means even before granting, I
Even-
thought that's a policy of USPTO to publish it.
By default, all patent applications are published 18 months after the filing, the first filing.
But you can stop the publication?
You have to request that.
Is there any reason why it's not a default not to publish? Why would anybody want to, before it's even approved, is there any reason?
Yeah, well, there are pros and cons. My cybersecurity clients don't like to publish the ideas.
Yeah.
But, there are reasons to publish. It's help with damages if you sue later. So you can say, oh, my invention was out of the public and it was willful infringement because they knew we were applying for a patent. So that, there are pros and cons, and it's, again, we have to...
It's going to be published anyway after 6 months. What's the point in stopping it publication from 6 months, for 6 months or so. Because once the patent is granted, it's published.
Well, yeah, patent is granted, usually it takes 2 to 3 years. If it goes smoothly, it can be even 5 years.
I've been gone through this process of patenting when I was an employee of IBM. I used to work with patent attorneys from New York and all that. I know how the whole process works. But out of that experience, I can find, for example, for small companies, okay, let's assume I file a patent, I get it. Where is the strength for a small company like me to monitor who is stealing and who is succeeding? It's a very big task. For example, I make a software, somebody steals in India and they are making tons of money. They are not here. I won't even know. Same thing with China. So only powerful companies have the monitoring mechanism or team to probe and research and find out, okay, this is the source code or whatever they have stolen from me. But small companies already filing a patent is draining a lot of money. And where is the mechanism for monitoring out of million companies out there? Unless that company becomes suddenly big, like Tesla or something, you won't even know. There are 10 companies who may steal your secrets, eat away all your business. You won't be even knowing. So in that case, really, the investment on patent, is it really worthwhile?
That's a very rare situation because most of the companies, you know what business you are in, you know your customers, and if there is a patent, your customers will tell you somebody else has infringed and all.
Yep.
Very rarely you find that you do not know.
Well, let's say you develop an app for a particular insurance application, whatever, right? Your customer doesn't know inside what you're doing, right? You're only showing some front-end screens and all that, whatever features. That features can be offered by another 1,000 companies. They won't even know whether they have stolen all the processes and all that. So I'm telling you, small companies, it's always a difficult thing.
Well, I would say there are 2 categories of patent filers. The companies that really, they want to protect their innovation, and they want to protect their market, and they want to, make some revenue from IP. And if you're a real company, then you're going to face the competition. For example, you're going to a customer, potential customer, say, oh, X and Y visited us yesterday, and they have a similar feature. They say, oh, really? We have a patent on that. Then that's for you a trigger to start and research if XYZ, is infringing on your patent. Now, there is no way, to know whatever is going in the world. I agree with you. But as a business owner, as a CEO, or, you need to know the competition. You need to know who is trying to steal your clients, and that's a customer, and that's a first step to see, if there is an infringement. Another type of filers, it's what we call patent trolls. These are people or companies today that they file patents just for the sake for suing others of infringing. And they have no products, okay? They have nothing. They don't sell anything. They just file patents, the way the patents to patent applications, the way the patents to be granted, and then they start to collect royalties or licensing fees through lawsuits. Their own goal is to monitor the big companies, small companies, and the like, and they will send letters, you're infringing on this patent, this is what we want to ask. If they know, they will proceed with the lawsuit. So for your questions, I think the best way is to look at the market, to look at the competition, and evaluate the competitors to see what they are up to. When we go and do this analysis, we examine white papers.
Manpower to do it. You are a small startup, right?
Well, for now, for startup, you don't use, and I'm going to touch that, I don't think that you need to use your IP for offensive. Okay? Why? Even if you find someone that infringes your patent, to start a lawsuit on infringement, you're talking about $1 million. That's without your time and the engineering's time. For startups, you use patents for defensive. If someone wants to sue you, so you have the tools or you have the assets to fight back, say, oh, you're infringing on my patent. And what I found, it really helps to leverage the valuation of the company through acquisition when we try to sell the business or when try to raise money. Okay, that's that's best of my experience. I will not say, okay, as a small startup, you're going to file patents and sue the world. You don't have the money for that. For those who develop softwares and familiar with the term open source software, so be very careful about the use of that. Every open source comes with a license. Read very carefully the license. I can tell you, first item to be checked on in due diligence for strategic investments or acquisition is, okay, give me all the licenses that you've been using to develop the product, and they carefully read all the open source licenses, and because it's can cause troubles. Sometimes the license was not right. Sometimes they adopted the license not in the right way, so they had to revise the code. So be very careful before using this type of software. I spoke earlier about who is the owner of the IP. So by default, the owner is the inventor. What you need to do when every time you need, as the company files for a patent, you need to sign the inventors on a document called an assignment, where the inventor assigns his rights in the patent application to the company. Very important to do that. Again, every due diligence, it's one of the things that's going to be checked. Companies will not acquire startups that they, and after acquisition is closed, they get a letter, Joe Smith was an inventor on this patent, and he has right on the invention, and he needs some, you didn't pay him the right amount, you should give him more equity in the company, he should part of the exit. They don't need these troubles. And, you don't need this trouble as well. So try to make sure that everything is assigned correctly. So we touched litigation, and I said that's not really for startups. Rare cases use that. On IP, it's difficult to litigate. It's expensive to litigate. Use your IP as defensive means to protect the company assets, but not as offensive. Again, that's what I suggest here. So we have this process that when we work with startup companies, that we help them to define a strategy. And we do that by evaluating really what is the technology that they have. We talk with the engineers trying to do some patent mining to understand what are potential inventions in the product. If we said about one, so we try to dig in and find more cool stuff to protect. We look at the competitions. We try to evaluate the IP landscape, how many patents the competitors are filed for. And we try to assess where they are going to, based on the IP they have now, what they need to file in order to go to my client territory. Of course, it's expensive, so we define a budget. And we try to say, okay, you have X thousands dollars. That's what we recommend to file. That's where we are going to file, and that's how we're going to file. We start with provisional for startups. Then we are going to do USPTO filings. We are going to decide carefully if we need to file elsewhere, because it's becoming it became very expensive if you go outside of the US. So that's part of the strategy we define for the company. And it's not one-time job. As we said, we support our clients see to exit, so we'll meet with them often. With some it's every month, with some it's every quarter, and reevaluate the strategy. Some it's just, okay, we launch a new product, or we're going to have this feature in this product, we think we should protect it or not. So we have an ongoing discussions with our clients about the strategy to make sure that it's aligned with their business goals. So that's a recap of what I said. When we discuss the strategy, we try to get inputs from the entire company. We will, for example, we speak with the product managers. Why? Because they are in direct touch with the customers. They know what the customers want to see in your product. They also talk with the competitors because, always you're not the one in the world. So, these guys came to us and they have this feature. What do you think? And they said to the PM, the PM said to the CTO, we should have this as well. And okay, so let's have a patent on that, even if you're not implemented that, just to stop your competition. So we tried to go over I would say, the entire spectrum of the company, from Q&A engineers to CEOs, to get inputs about what should be the strategic decision with regards to IP. For example, with the CEOs, we'll ask about, okay, when is your next round? What is your exit plan?
Just one more thing. You talk about features, right? Let's say you are in the sales space. Take, for example, CRM space, right? You see a lot of CRMs. Everybody has the same kind of model. Forget about the technology. Technology stack could be different, but features are same. So you're talking about patenting features, because you cannot do that, right? Like if there is a small company somewhere, it has the same features, and you have a Salesforce, or you have, for matter, Microsoft Dynamics, they also have the same features. How do you do IP patenting on that?
So you can protect the how, for example, how you implement that. If you implement it differently, then that's a way to patent. But sometimes you have a new feature that one has put it in the product yet, so you do want to protect that. So you will have advantage over your competition.
So ideally, a product lifecycle, there is a roadmap. It's not like all of a sudden I say, I want to put that feature. There's a product roadmap on which features are listed. Now, you eventually, if I'm trying to sell it to a client, I'm going to say that, hey, this is my product roadmap. That's why clients get attracted to start investing.
Exactly, and because you said...
My point is, like, let's say there's somebody else who's coming up, but he is a little bit faster than me in my roadmap. Similar roadmap, but they are a little bit faster. What is the advantage they would have of sharing that feature ahead of me?
Yep. Okay, so you can file a patent application on future implementations, okay? So if you have a roadmap for the features you're going to have in 5 years, why don't you protect them now? Okay, you can do that. So, but if I will talk with one engineer, the company, I have no full vision about what the product is going to be like in 5 years. So that's what you try to go over and talk with a lot of people in the company to understand the future, the present, and try to capture that through an IP strategy.
Respecting the time, we will have the question afterward.
Wanted to go first?
Summarize a bit. Yeah. It gives an opportunity to meet again and schedule some more down the line.
Okay. So I have some example of value of IP, but I will touch the last one, which is most recent. Apple acquisition of Intel's part of modern business, $1 billion. And Intel had about 8,500 assets, which mean patents and patent applications. And after the acquisition, that's the number of 17,000 patents that Apple holds. So a big number, I think in part, it started by Intel placing their IP portfolio, the patent portfolio, in the smartphones modem business for auction. And through the auction, Apple decided to acquire the patent portfolio and also to acquire the technology and the people that work on this in this business unit. So let's talk about, I touched it a little bit, but just as a summary, the way we work is we have a very simple process. And our claim to fame is that we reduce the time that inventors or engineers spend with us working on patent applications. On average, you can find that an engineer working with us will spend no more than 5 hours from the first time he described the invention until it is filed with the USPTO. We achieve that not because we are super smart, because we have a process that we have developed over time. We start by understanding the business goals and the technology in the company, and as I said before, we develop an IP strategy for the company. Then we do what we call a patent mining sessions. And what I found that's the one thing that helps accelerate innovation in startup companies. The reason is when every time I go and start these discussions, I will go to the room full of engineers, say, okay, anyone can tell me about their ideas or the patents? They're quiet. Oh, whatever we do here is simple, is obvious, is trivial. So I reply, so why do you get paid? Because we develop stuff. Okay. And then we start the discussion. And I don't ask them what you invented. I just ask them, describe me what you're doing. We ask the right questions, and by that we're able to identify valuable inventions that later we decide whether to file or not. So usually we end a session like that with tens of potential inventions, and we suggest to file those that really align with the IP strategy. Otherwise, to us, it's waste of money. I will never file a patent application just to make someone happy. It's costly, and I don't see any reason to do that. Once we decide on an application to file, we work directly with the engineer. We have an in-depth discussions with them. We interview. We ask them all the technical questions that help us to formulate the patent application. So as Dennis mentioned, we are going to help PGA and PGA companies. So that's our offering to any of companies that will come through PGA, is that we'll develop the strategy at no charge. We'll do a patent mining session at no charge. And we'll also give you some discounts on our standard rates.
What is your cost of filing a utility patent?
The cost?
Filing a utility patent.
Typically, we charge about $10,000 in the US full utility application. Well, it depends on the industry. Like software, hardware, that's the number you're looking at.
I'm talking about software.
Yeah.
Around $10,000.
For full patent application, yeah, including fees and stuff like that. Patents related to software on not being eligible because of a court decision around Alice. I don't want to talk about that now, but they basically said that every idea that is considered as an abstract idea is not really considered as a patent. And then examiners, the USPTO, decided everything in the world is abstract idea. It became a problem, and recently, 2 months ago, the commissioner published new rules that really put limits or broader, defined what is abstract idea and what is not. And now we see more and more patents are being allowed that were thrown by examiners not really understanding the case law. For the quick. So yeah, I know, but just wanted to expand on that. So obviousness, it's another big problem, and there are ways, legal tests to determine what is obvious and what is not obvious. We do it by looking at the law, and what I trying to assess when I evaluate whether to file or not to file a patent, what is the inventive step? Okay, assuming that everything, what is known in the art, in the prior art, that's what I know. Okay, what you're proposing. And I look at the delta and I say, okay, I'm an engineer. Is it really an inventive step here or not? And then I go to the test defining the tech in the law book, in the regulations of the USPTO, and apply that. I can tell you when we argue against, when we prosecute patent application, when we argue, I never go and say, oh, I cite this case just because XYZ it's not obvious. I discuss the technology with the examiners and I argue the technology. And it's very difficult for them to win when I argue about the technology. For example, if I can prove that the network in this is a patent application and the network in the other patent application that the examiner is trying to combine are this is centralized and this is distributed, and I explain the differences on the technology, then for them it's say, okay, you're right, because that cannot be combined together. So, that's the way we fight back. Questions?
Yeah. The most interesting stage of the whole thing is preparing the draft. Yes, when I was doing for IBM, I think they were charging $40,000 or something for that pattern, whatever I was working on IBM server. That was the name. So initially I had a complete detailed design and all that. They studied and came back and had a discussion like, when they chopped off the details, I was, as a real inventor, I was really upset. How can you take off? That's the whole crux of it. They say you don't understand. Business point of view, if you give so much of detail, they are going to bypass that and achieve the same result and still claim their pattern. So you have to keep it at a higher level and keep it vague.
Yep.
So like that, 4 iterations, So
The art is how to claim it broadly, but in details that, some reader patterns can implement that. I can tell you that we don't take any drafts from inventors, only if they're willing to share with us. We find it more time-saving and helpful that we talk with the inventors on a whiteboard or face-to-face, or and help them to and ask them to describe what they have invented. And then we come with the basic drawings and the basic claims, and once they approve that, we go and extrapolate it to 3 pages of
what is the
application.
general turnaround time now? Because that time itself is going to, for the patent to file.
It depends on the art unit, but software are looking about 2 to 3 years now until you get
At
it.
that time, 1 year was too long. So now it's,
You can get it accelerated, but that's the government.
Thank you.
Thank you.